The building stood in downtown Chicago, like every other corporate tower. Glass, steel, and silence polished to look intentional. From the outside, it promised order, professionalism, opportunity. From the inside, it demanded obedience, visibility, and noise. She never gave them noise. Her name was Evelyn Carter, a woman in her early 30s, slim, always neatly dressed in muted colors, grays, soft blues, nothing that invited comment. She walked with measured steps, shoulders slightly tense, eyes observant rather than avoidant. Evelyn wasn't shy. She wasn't insecure. She was attentive. She listened more than she spoke, absorbed details others ignored, and preferred precision over performance. At Redwood and Blythe Consulting, that made her an anomaly. The firm thrived on loud confidence, open offices, glass-walled meeting rooms, forced laughter during brainstorming sessions. The company culture rewarded those who dominated conversations, who interrupted with certainty even when they were wrong. Meetings weren't about solutions, they were about presence, and presence in that world meant volume. Evelyn had been hired as a compliance analyst. Her job was to review internal reports, flag inconsistencies, and ensure the company's operations aligned with federal and state regulations. She was good at it. Exceptionally good. In her first year, she caught 3 reporting discrepancies that could have cost the firm millions in fines. Each time her findings were quietly corrected, her name barely mentioned. Her manager, Richard Harlow, embodied everything the company celebrated. Mid-40s, tailored suits, sharp jaw, voice that filled rooms effortlessly. He spoke in absolutes, smiled without warmth, and treated meetings like performances with himself as the lead. He valued people who mirrored him. Assertive, outspoken, visibly ambitious. Evelyn was none of those things. At first, Richard ignored her. Then he started noticing her silence. It began subtly. During meetings, he would pause after asking a question, eyes scanning the room before landing on her. "Evelyn," he'd say, tone light but pointed. "Any thoughts? Or are you just here to observe?" A few chuckles would ripple through the room. Evelyn would respond calmly, offering concise, accurate input, often the most practical suggestion in the room. Richard would nod, then immediately redirect attention elsewhere, reframing her idea in louder words spoken by someone else. Over time, the comments escalated. "You need to speak up more. You're hard to read. People don't know what you're thinking. This isn't a library, Evelyn." Each remark was delivered casually, always in front of others, always framed as feedback. Never written, never official. What no one noticed, what no one ever did, was how Evelyn adapted. She began carrying her phone everywhere, not openly, not obviously, just present. Voice memo apps were legal in Illinois under one-party consent. She knew that. Compliance was her field. Regulations weren't abstract concepts to her. They were structures she trusted when people failed her. At first, she recorded out of instinct, a quiet sense that something wasn't right. That the way Richard spoke to her, the way decisions were made behind closed doors, the way certain numbers disappeared from reports, it all felt connected. Weeks passed, then months. She recorded meetings where Richard dismissed concerns about overtime reporting, conversations where senior staff joked about adjusting figures before audits, private one-on-one check-ins where Richard leaned back in his chair and told her, smiling, "You'd go further here if you had more personality." The final meeting came on a Tuesday afternoon. Human resources, neutral walls, a single plant in the corner, artificial and immaculate. Richard sat beside Karen Lewis, the HR director, professional, expression carefully blank. Evelyn noticed the folder on the table before anyone spoke. Her name typed neatly on the tab. Karen did most of the talking. They praised Evelyn's technical skills, her accuracy, her reliability. Then came the pause, the one that always preceded something unpleasant. The concern, Karen said, folding her hands, is cultural fit. Richard leaned forward. You're very quiet, Evelyn. Too quiet. In a collaborative environment, that can be disruptive. Disruptive. The word landed heavier than he intended. They framed it as a mutual decision. A misalignment. Severance paperwork slid across the table. No mention of performance issues, no warnings, just a conclusion already made. Evelyn listened. She nodded once. She didn't argue. She didn't cry. She didn't ask for reconsideration. What she did was press her phone screen, once, inside her bag. When she left the building for the last time, the city felt louder than usual. Cars, voices, construction, all of it collided into a dull roar. She stood on the sidewalk for a long moment, clutching the box with her belongings, breathing steadily. They thought her silence meant compliance. They thought quiet meant harmless. They thought observation meant weakness. They had no idea what she had been collecting. And they had no idea how much the law valued the truth, when it was preserved carefully, patiently, and in full. After her termination, Evelyn didn't rush home. She walked instead, moving through the late afternoon streets of Chicago as the city transitioned from corporate order to evening chaos. Office workers spilled onto sidewalks, loosening ties, checking phones, laughing too loudly. The same people who filled meeting rooms with noise now flooded the streets with it. Evelyn moved among them unnoticed. Her apartment was small but intentional. Clean lines, neutral tones, shelves organized with methodical care. Nothing extravagant, nothing careless. A space designed for clarity. She placed the cardboard box on the kitchen table and removed its contents slowly. A framed certification, a company-issued notebook, a desk plant she'd kept alive for 3 years. Then she locked the door and sat down. Only then did she open her laptop. Compliance work had trained her to think in systems rather than emotions. When something failed, you traced it backward. You documented. You cross-referenced. You verified. Evelyn approached her own situation the same way. She transferred the audio files one by one into encrypted folders, labeling each with dates, locations, and participants. Some recordings were short, comments made in passing. Others stretched for over an hour, filled with voices layered over one another, laughter masking intent. She listened carefully, taking notes, tagging moments where language crossed from unprofessional into illegal. As she worked, faces surfaced in her mind. Richard Harlow, her former manager, wasn't just loud. He was calculated. His authority came from confidence, but his decisions came from convenience. Regulations were obstacles to him, things to work around rather than uphold. He trusted that people like Evelyn would remain invisible, that they would do the work without asking questions too loudly. Then there was Karen Lewis, the HR director. Early 50s, immaculate posture, carefully neutral expressions. Karen believed deeply in process, but not necessarily in justice. Her loyalty wasn't to employees, it was to stability. She smoothed conflicts, documented just enough, and ensured the company was always protected, especially from itself. Evelyn had once admired her. Beyond them were the secondary figures, analysts who stayed silent out of fear, managers who laughed along, executives whose voices appeared only occasionally on the recordings, distant but decisive. None of them saw themselves as villains. They saw themselves as practical. Chicago itself mirrored the company, impressive, efficient, layered. A city shaped by regulations, unions, courtrooms, and precedent. Evelyn knew the laws here mattered. Illinois protected whistleblowers. One-party consent laws made her recordings legal. Federal compliance violations carried weight if proven with evidence, not emotion. That knowledge steadied her. Still, she wasn't immune to doubt. Late one night, she paused a recording halfway through. In it, Richard joked about massaging numbers before an audit. Laughter followed. Someone mentioned that compliance would never push back too hard. Evelyn heard her own voice in the background, quiet, measured, asking a question that shifted the conversation. The room fell silent for a moment before moving on. She closed the laptop. Being quiet had never meant being passive, but the world often confused the two. The next step wasn't impulsive. She didn't send anonymous emails or post clips online. Instead, she researched attorneys who specialized in employment law and corporate misconduct. She read court filings, past verdicts, settlement patterns. She looked for someone who understood evidence, not outrage. That was how she found Daniel Moreno. Daniel was a mid-40s attorney based near the Loop, known for taking complex whistleblower cases that corporations preferred to bury. His reputation wasn't built on dramatic press conferences, but on meticulous preparation. When Evelyn scheduled a consultation, she expected skepticism. She got focus. Daniel listened without interrupting as she explained her role, her termination, and the existence of the recordings. When she slid a flash drive across the desk, his expression didn't change. He simply asked one question. "Did you alter any of these files?" "No," Evelyn replied. "Did anyone know you were recording?" "No." "And were you legally allowed to?" "Yes." Daniel nodded once. That was it. No reassurances, no speeches. Just a measured response that told her he understood exactly what she had brought into his office. Outside, the city moved on. Redwood and Blythe continued operating. Richard continued managing. Karen continued documenting. Internally, Evelyn's departure was framed as a cultural mismatch, nothing more. But beneath the surface, the world had shifted. Evelyn wasn't alone anymore. She had documentation, legal structure, and a clear path forward. The environment that once silenced her had, without realizing it, given her everything she needed. And for the first time since the termination meeting, she felt something close to momentum. The first letter from Daniel arrived at Redwood and Blythe on a Thursday morning. It was formal, restrained, and impossible to ignore. The firm's legal department received it first, a notice outlining wrongful termination, retaliation, and potential violations of federal compliance laws. It referenced evidence without revealing its full scope. Enough to signal seriousness, not enough to show their hand. By noon, Richard Harlow had already heard about it. His reaction wasn't panic. It was irritation. He paced his office, phone pressed to his ear, lowering his voice whenever someone passed the glass walls. To him, this wasn't a legal threat. It was an inconvenience. A former employee trying to reclaim relevance. He trusted the system to protect him, the way it always had. Karen Lewis didn't share his confidence. She read the letter twice, then a third time, slower. Certain phrases stood out. Documented patterns, recorded meetings, retaliatory dismissal. Her jaw tightened. Karen believed in plausible deniability. This letter suggested something more dangerous: documentation. That afternoon, an internal meeting was called. Not the kind announced on shared calendars. Invitations were sent quietly, selectively. Evelyn's name was never spoken aloud, but she occupied every silence in the room. "We don't know what she has," one executive said. Richard scoffed. "She barely spoke in meetings. What could she possibly have?" That assumption, the same one that had cost them before, settled heavily over the table. Meanwhile, Evelyn waited. Daniel had advised patience. Corporations, he explained, rarely responded well to pressure at first. They tested boundaries, minimized risks, tried to intimidate without leaving fingerprints. Evelyn understood that logic. She had lived inside it for years. Still, the waiting carried weight. Emails went unanswered. Former colleagues stopped responding to her messages. A woman she'd once eaten lunch with crossed the street to avoid her. The narrative had already begun to form inside the company. Disgruntled employee, overreaction, misinterpretation. Then came the call, an unfamiliar number, a controlled voice on the other end. "Evelyn, this is Karen Lewis from Redwood and Blythe. We'd like to resolve this amicably." Amicably meant quietly, quickly, on their terms. Daniel advised her not to respond directly. He returned the call instead. 2 days later, the firm offered a settlement. Modest, conditional. It included a non-disclosure agreement so broad it would have erased the last 3 years of Evelyn's life. In exchange, they acknowledged nothing. Evelyn didn't hesitate. She said no. That was when the tone changed. Redwood and Blythe's attorneys began questioning the legality of the recordings. They suggested Evelyn had misunderstood conversations. They implied she had recorded selectively, out of context. Subtle threats followed: defamation countersuits, drawn-out litigation, professional blacklisting. Each move was designed to exhaust her. Instead, it sharpened the conflict. Daniel responded not with arguments, but with filings. He submitted transcripts of audio clips, just enough to demonstrate a pattern. In one, Richard explicitly dismissed compliance concerns. In another, a senior manager joked about audit timing to keep regulators confused. None of it illegal on its own. Together, it painted intent. The Department of Labor took notice first. Then the Securities and Exchange Commission requested information. Redwood and Blythe's internal atmosphere shifted. Employees whispered. Meetings became shorter, stiffer. Compliance reviews were suddenly thorough. Richard stopped making jokes. Karen stopped smiling. Evelyn watched it all from a distance. She didn't feel triumphant. She felt focused. There were moments of doubt, nights when she replayed recordings, wondering if she had done enough, or too much. She worried about being reduced to a headline, her silence reframed as deceit. But every time uncertainty crept in, she returned to the facts, the files, the timestamps, the voices that hadn't known they were being preserved. The conflict intensified when Redwood and Blythe filed a motion to dismiss. They argued that Evelyn's termination was lawful, citing performance reviews that praised her work, but noted communication challenges. They framed her quietness as incompatibility, not retaliation. It was a familiar story, one designed to sound reasonable. Daniel countered with evidence. He demonstrated how the language in her reviews changed only after she raised compliance concerns. How meetings referenced in the recordings aligned with sudden shifts in internal reporting. How cultural fit became a convenient justification when compliance became inconvenient. The case moved forward. Subpoenas followed. Depositions were scheduled. Richard was forced to sit in a conference room, under oath, listening to his own voice played back to him. Karen answered questions with careful precision. Each response weighed against what might already exist in audio form. Evelyn attended none of it in person. She didn't need to. Her role in the conflict had already changed. She was no longer reacting. She was no longer defending herself. The system that had once dismissed her as too quiet was now required to listen, carefully, legally, and in full. And as the pressure mounted, it became clear that this wasn't just about her termination anymore. It was about everything they thought no one was paying attention to. As the case advanced, new layers emerged, ones that had never been visible from Evelyn's desk. The first came through discovery. Documents obtained through subpoenas revealed internal emails that mirrored the tone of the recordings. Compliance concerns dismissed as overcautious. Financial adjustments labeled as temporary corrections. Language softened. Responsibility blurred. What had once felt like isolated moments now formed a consistent pattern. But the most revealing complexity wasn't in the paperwork. It was in the people. One afternoon, Daniel forwarded Evelyn an email from an unknown sender. The message was brief, carefully worded, and unsigned. I worked with you. I saw what happened. I have information. But I'm scared. Evelyn stared at the screen for a long time. Fear was the firm's most effective tool. It didn't need to be enforced openly. It lived in promotions not given, in contracts not renewed, in reputations quietly damaged. Redwood and Blythe didn't threaten people. It simply outlasted them. Daniel advised caution. Whistleblowers within whistleblower cases complicated everything. Still, Evelyn responded. They met weeks later in a quiet cafe far from downtown. The woman who arrived introduced herself as Maya Thompson, a junior analyst in her late 20s. Her hands trembled slightly as she wrapped them around her cup. Maya spoke in fragments at first, then in patterns. She described being instructed to revise numbers without documentation, being told certain questions weren't worth asking, watching Evelyn raise concerns in meetings, and noticing how the room shifted afterward. She admitted she'd saved emails, screenshots, drafts she'd been told to delete. I thought staying quiet would protect me, Maya said. Then I saw what they did to you. Maya's information didn't change the case's direction. It deepened it. At the same time, pressure mounted inside Redwood and Blythe. Karen Lewis found herself trapped between roles. As HR director, she was expected to protect the company. As a professional bound by ethics, she was now under scrutiny for what she had ignored. Her deposition reflected that tension. When asked about Evelyn's termination, Karen emphasized procedure. When confronted with recordings where she dismissed concerns as not strategic, her answers slowed. She didn't lie. She reframed. But reframing had limits when audio existed. Richard, on the other hand, became unpredictable. Colleagues noticed his temper shortening. Meetings grew tense. His confidence, once effortless, now felt forced. He began blaming others for mistakes, distancing himself from decisions he had once owned proudly. The internal conflict fractured alliances. Some executives pushed for settlement, others insisted on fighting to avoid setting precedent. Shareholders began asking questions. A routine compliance review turned into a formal inquiry. Outside the firm, Evelyn faced her own complexities. Friends advised her to move on, to find another job, to stop living in the past. Potential employers, after background checks, stopped calling back. The case followed her quietly, invisibly shaping opportunities. She questioned herself more than once. Was justice worth the cost? The answer wasn't philosophical. It was practical. If she walked away now, nothing changed. The patterns continued. The silence persisted, just with someone else's name attached. Another subplot emerged when the media took interest. A business journalist requested comment on an ongoing employment dispute. Daniel declined. For now. Exposure could help, but it could also distort. Evelyn didn't want her story simplified into outrage or spectacle. She wanted it understood. The final complexity arrived unexpectedly. Karen Lewis requested a private meeting with Daniel, not to negotiate, to clarify. She didn't confess. She didn't accuse. She spoke about systems, about gradual erosion of boundaries, about how small compromises became habits. Her statements didn't absolve her, but they reframed her role, from villain to enabler. It added moral weight to the case. This wasn't a story about monsters. It was about structures that rewarded noise and punished restraint, that confused compliance with obstruction, that mistook quiet attention for weakness. As timelines converged and subplots tightened, the pressure became inescapable. A court date was set, and with it came the certainty that the story, every part of it, would soon be heard in full. The turning point didn't arrive with a verdict or a headline. It arrived quietly, through a court order. 2 weeks before trial, the judge granted a motion compelling Redwood and Blythe to submit all internal compliance communications from a 3-year period. Not summaries, not curated excerpts, everything. The ruling shifted the balance instantly. Inside the firm, the order triggered panic disguised as productivity. IT teams worked overnight. legal advisors flooded conference rooms. Executives demanded assurances that no further surprises existed, assurances no one could honestly give. Richard Harlow learned about the order during a board call. His voice remained steady as he acknowledged it, but something fractured beneath the surface. For years, he had relied on plausible deniability, on the assumption that what wasn't documented didn't exist. Now documentation was unavoidable. Karen Lewis read the order alone in her office. She understood its implications better than anyone. HR communications, internal reviews, performance notes, things never meant to leave the building, were now subject to examination. Context would no longer be controlled. That afternoon, she made a decision. She instructed her assistant to pull archived files she had never intended to revisit, emails she'd flagged but never escalated, meeting notes where concerns had been raised and dismissed. Her own comments, carefully neutral at the time, now felt dangerously close to acknowledgement. Across the city, Daniel called Evelyn. "This changes things," he said simply. The expanded discovery revealed something no one had anticipated. A recorded internal meeting from 2 years earlier, stored on a shared drive and forgotten. In it, Richard openly discussed restructuring compliance roles to reduce friction. He referenced Evelyn by first name. "She's smart," Richard said in the recording, "but she watches too much. We need people who move fast, not people who slow us down with questions." The room laughed. The audio didn't just support Evelyn's claim. It reframed her termination as premeditated. When the recording was submitted as evidence, Redwood and Blythe's legal strategy collapsed. Settlement talks reopened, urgently this time. The offer tripled, then quadrupled. Conditions softened. Language shifted. The non-disclosure clause was reduced. Evelyn listened to the proposals in silence. For the first time, she considered accepting. Not out of fear, but exhaustion. The case had consumed her life. Every day revolved around evidence, timelines, and legal strategy. The temptation to end it, to reclaim normalcy, was real. Daniel didn't push her either way. "Winning isn't just money," he reminded her. "It's leverage." The turning point came during Richard's deposition. Under oath, confronted with the recording, he attempted to explain it away. He framed it as frustration, as humor, as misinterpretation. But the tone of his voice betrayed him. Casual, confident, dismissive. When asked whether Evelyn's quietness factored into her dismissal, he hesitated. "Yes," he said finally. "It affected team dynamics." The admission was small, controlled. It was also fatal to the defense. The room shifted. Attorneys exchanged glances. The court reporter's fingers moved steadily, capturing every word. That evening, Karen Lewis resigned. Her letter cited personal reasons. The timing spoke louder. Media interest intensified. Still controlled, still careful, but present. Headlines avoided drama, focusing instead on systemic issues, corporate accountability, and the growing scrutiny of workplace retaliation. For the first time, Evelyn's name appeared publicly, not as a complaint, but as a plaintiff. She felt the weight of it immediately. Being heard was powerful. Being visible was something else entirely. The final settlement offer arrived 3 days later. It included full compensation, legal fees, and, most importantly, a formal acknowledgement that her termination had been mishandled. No admission of guilt, but no denial either. The firm also agreed to external compliance oversight for 3 years. It wasn't everything, but it was enough to change the story. Evelyn didn't accept immediately. She walked through the city that night, past the same buildings that once intimidated her. She realized something then. This had never been about revenge. It was about correction, about forcing a system to recognize the cost of ignoring those who pay attention. The next morning, she called Daniel. "I'm ready," she said. And with that decision, The direction of the story was no longer in Redwood and Blythe's control. The consequences unfolded in layers, not all at once. The settlement became public within days, stripped of drama, but heavy with implication. Redwood and Blythe issued a carefully worded statement, emphasizing organizational growth and process improvement. It avoided naming individuals. It avoided apologizing, but it couldn't avoid scrutiny. Inside the firm, the reaction was immediate. Departments froze. Projects stalled. Employees watched leadership with a new kind of attention. Less admiration, more calculation. Conversations lowered in volume. Emails became cautious. The culture that once rewarded loud certainty now hesitated under its own echo. Richard Harlow took an indefinite leave of absence. Officially, it was to focus on personal matters. Unofficially, everyone understood what it meant. His authority evaporated almost overnight. The man who once dominated rooms now existed only in absence, his influence reduced to recordings and transcripts replayed in legal contexts. Karen Lewis's resignation triggered its own ripple effect. HR policies were reviewed externally. Termination procedures were audited. Training sessions on retaliation and compliance became mandatory. Not because the firm had discovered ethics, but because it had discovered exposure. For the first time, silence inside Redwood and Blythe carried a different meaning. It wasn't invisibility. It was caution. Evelyn felt the consequences more personally. Her inbox filled with messages she hadn't expected. Former colleagues reached out quietly, some apologetic, others simply relieved. A few admitted they'd known things were wrong, but hadn't known how to act. One message stood out. "Thank you for doing what I couldn't." The words stayed with her. Not all reactions were supportive. Online commentary ranged from measured analysis to casual dismissal. Some questioned her motives. Others framed her as opportunistic. The same assumptions that had followed her at work now appeared in public discourse. She didn't respond. She didn't need to. Daniel advised her to step back from the process as much as possible. The case was technically over, but its aftershocks were still settling. Evelyn took his advice seriously. She declined interviews. She avoided panels. She resisted being turned into a symbol. Instead, she focused on something simpler: reclaiming her time. The financial security from the settlement removed immediate pressure, but it didn't erase uncertainty. Re-entering the job market felt different now. She was more selective, less willing to tolerate ambiguity disguised as culture. She accepted a short-term consulting role with a nonprofit focused on workplace compliance education. The work was quieter than her previous job, but more honest. Conversations centered on prevention rather than damage control. Evelyn noticed a shift in herself. She still didn't speak unnecessarily. She still listened more than she talked, but she no longer shrank when others filled the space. Silence, she'd learned, could be deliberate, strategic, powerful. Redwood and Blythe continued operating, but not unchanged. External auditors remained embedded. Board members rotated out. Processes slowed. For a company built on speed and certainty, the adjustment was uncomfortable. Necessary. The broader industry took note. Legal briefings referenced the case. Compliance seminars cited it as an example, not of scandal, but of consequence. Quiet employees were no longer dismissed as passive by default. Evelyn watched all of this from a distance. There was no moment of triumph, no final confrontation. Just the steady realization that her actions had altered something larger than her own situation. The system had been forced to listen, and while the noise of the world hadn't disappeared, it had shifted, making room, at last, for voices that didn't need to be loud to be heard. The end of the case didn't feel like an ending. For Evelyn, it felt more like the removal of pressure, like finally being able to breathe without anticipating interruption. But growth didn't arrive as relief alone. It arrived as adjustment. For years, her sense of value had been measured against an environment that dismissed quiet as absence. Now that environment was gone, and she had to recalibrate something deeper. how she defined her own presence. The consulting role at the nonprofit started slowly. The organization occupied a converted warehouse on the south side, far from glass towers and executive floors. Desks didn't match. Meetings didn't have agendas polished for appearance. People spoke with intention rather than performance. At first, Evelyn observed. Old habits lingered. She took notes while others spoke. She waited for pauses that never came. But this time, no one mistook her silence for disengagement. When she spoke, people listened, not because she demanded attention, but because she brought clarity. That difference mattered. Her work focused on designing compliance frameworks for small and mid-sized companies, structures that didn't just exist on paper, but accounted for human behavior. She helped build reporting systems that protected employees from retaliation, training modules that explained not only what the law required, but why it mattered. In those sessions, she noticed something new about herself. She spoke more, not loudly, not often, but deliberately. She no longer questioned whether her voice belonged in the room. The trial had stripped that doubt away. She had seen, in undeniable terms, the impact of paying attention, and the cost of ignoring those who did. Still, growth wasn't linear. There were moments when old instincts resurfaced, networking events where confidence was still measured in volume, interviews where hiring managers praised her attention to detail, but hesitated at her composure. She learned to recognize the signs, not as warnings, but as filters. She didn't need every door to open. She needed the right ones. One afternoon, Daniel invited her to lunch. They hadn't spoken much since the settlement closed. Their relationship had been professional, precise. But now, with no deadlines pressing between them, the conversation shifted. "You know," he said, stirring his coffee, "cases like yours don't usually change people. They harden them." Evelyn considered that. "I don't feel hardened," she replied. "I feel calibrated." Daniel smiled. "That's rare." The growth showed itself most clearly when Maya reached out again. Maya had left Redwood and Blythe shortly after the settlement, quietly resigning before the next compliance audit began. She was uncertain about her next steps, unsure whether speaking up had cost her more than it had given. They met again, this time not out of fear, but reflection. Evelyn didn't offer advice. She shared process instead. How she evaluated risk. How she decided when silence protected her and when it enabled harm. How recording hadn't been an act of defiance, but of preparation. Maya listened closely. For the first time, Evelyn recognized herself as something she had never aimed to be, a reference point. Growth wasn't about becoming louder. It was about becoming anchored. She began speaking at small workshops, not as a keynote, but as a contributor. She explained how compliance failures often began with dismissed voices, how organizations confuse disruption with danger and silence with consent. She never dramatized her story. She let the facts speak. Internally, she noticed her behavior changing in subtle ways. She interrupted when necessary. She corrected assumptions without apology. She no longer softened statements to protect egos. And when she chose silence, it was intentional, not imposed. The quiet that once isolated her had transformed into something else entirely. Control. By the end of the year, Evelyn declined a full-time corporate offer from a large firm impressed by her case history. Instead, she accepted a hybrid role, part consulting, part independent oversight. It gave her autonomy, distance, balance. The growth wasn't visible from the outside. No headlines marked it. No applause followed. But inside, something fundamental had shifted. She no longer measured herself against environments that couldn't hear her. She measured environments against their ability to value attention, integrity, and restraint. And for the first time, she trusted herself completely to know the difference. What remained unresolved wasn't legal. It was structural. Although the settlement had closed Evelyn's case, the broader inquiry into Redwood and Blythe was still unfolding. External auditors remained embedded inside the firm, and regulatory agencies continued reviewing years of internal practices. The system had acknowledged failure, but acknowledgement didn't guarantee accountability. Evelyn understood that distinction better than most. In the months following her personal growth, requests began arriving indirectly. Not interviews, not testimonials. Quiet inquiries from compliance officers, nonprofit boards, and legal clinics asking for clarification on one thing: how patterns like Redwood and Blythe's went unnoticed for so long. She didn't frame her responses as warnings. She framed them as maps. She explained how culture shaped behavior long before policy failed, how employees learned what not to document, how tone in meetings signaled what questions were welcome and which were dangerous. Preparation for misconduct, she noted, often looked identical to efficiency until examined closely. At the same time, Redwood and Blythe prepared its own defense. Regulators requested sworn statements from senior leadership. Internal reviews uncovered inconsistencies that could no longer be attributed to oversight. The firm hired a public relations consultant to manage narrative, attempting to present cooperation as transparency. But tension simmered beneath the surface. Several former employees came forward independently, their accounts aligning with Evelyn's experience. None had recordings, but they had timelines, emails, performance reviews that shifted without explanation. Individually, their stories were inconclusive. Together, they formed a pattern. Daniel contacted Evelyn one evening. "They're moving toward formal charges," he said. "Not against individuals, against the firm." That distinction mattered. This wasn't about punishing a single manager or correcting a procedural error. It was about forcing institutional change, the kind that required public accountability, not private settlements. Evelyn felt the familiar weight return, not fear, but responsibility. She wasn't obligated to participate further. Her case was closed. Her risk had already been taken. But preparation for the climax of the broader story required something more than documents. It required context. She agreed to provide a sworn statement, not as a plaintiff, but as a witness. The process was controlled, methodical. She reviewed transcripts, timelines, and regulatory frameworks. She didn't speculate. She didn't exaggerate. She explained precisely how decisions had been made, how silence had been interpreted, and how retaliation had been rationalized. Every word was deliberate. Meanwhile, inside Redwood and Blythe, pressure accelerated. Board members distanced themselves. Executives retained independent counsel. The firm's once confident messaging fractured into competing narratives: growth versus accountability, cooperation versus exposure. Richard Harlow's name resurfaced, not as a rumor, but as a documented influence. His leave of absence extended indefinitely. Emails revealed how frequently his preferences shaped compliance responses. The firm could no longer isolate blame. As the date for the regulatory hearing approached, preparation intensified on both sides. Evelyn prepared not to speak dramatically, but to be precise. She rehearsed answers with Daniel, focusing on clarity over persuasion, facts over feelings, structure over story. The irony wasn't lost on her. The same traits that had made her too quiet now made her indispensable. On the eve of the hearing, she walked through Chicago again, past the courthouse, past the firm's tower, past spaces that once represented authority. She felt no anger toward them, only readiness. The climax wasn't going to be loud. It was going to be unavoidable. The hearing took place on a gray morning, the kind that flattened the city into muted tones. The federal building stood heavy and unmoving, its stone facade indifferent to the tension gathering inside. There was no audience waiting outside, no cameras, no spectacle. Inside, everything mattered anyway. The room was structured for control: long tables, fixed microphones, flags positioned precisely behind the panel of regulators. Every sound carried. Every pause stretched longer than intended. Evelyn entered quietly and took her seat. Across the room sat Redwood and Blythe's legal team, their posture rigid, expressions carefully neutral. Several executives were present, though none met her eyes. The absence of Richard Harlow was conspicuous. His name, however, was everywhere, in documents, transcripts, timelines. The hearing began without ceremony. Regulators outlined the scope of the investigation, patterns of retaliation, suppression of compliance concerns, and systemic misrepresentation. It was technical, methodical. But beneath the language lay something sharper, a recognition that this wasn't an isolated failure. Then, Evelyn was called. She stood, adjusted the microphone slightly, and was sworn in. Her voice, when she spoke, was calm, even, unembellished. She described her role at the firm, her responsibilities, the expectations placed on compliance analysts. She explained how concerns were raised, how they were redirected, softened, or delayed. She referenced dates, meetings, and decisions without emotion. When asked about her termination, she didn't argue intent. She described sequence. Concerns raised, tone shifted, documentation changed, silence reframed as deficiency. The regulators listened closely. Then came the recordings. Short excerpts were played, not for drama, but for corroboration. Richard's voice filled the room, confident and dismissive. Laughter followed statements that now sounded unmistakably reckless. The room remained silent this time. Evelyn didn't react. She didn't need to. Redwood and Blythe's counsel attempted to reframe the narrative. They argued cultural misalignment, misinterpretation, management style. They emphasized cooperation and reform. Then a regulator asked a single question. If compliance concerns were valid, he said, why was the employee raising them removed instead of the issue being addressed? The silence that followed was heavier than any argument. No one answered immediately. That was the moment the climax crystallized, not in confrontation, but in exposure. The system was forced to confront its own logic, laid bare and unprotected. Further testimony followed. Former employees spoke, not dramatically, but consistently. Different roles. Same patterns. Different managers. Same outcomes. What had once been dismissed as individual dissatisfaction now formed a structure too coherent to ignore. Finally, the regulators delivered their preliminary findings. Redwood and Blythe had failed to protect compliance processes. It had allowed cultural bias to override legal responsibility. It had retaliated, directly and indirectly, against employees whose restraint had been mistaken for obstruction. Sanctions were announced. Mandatory external oversight, substantial financial penalties, required structural reforms, public disclosure of findings, not symbolic, enforceable. Evelyn listened as the ruling was read. She felt no surge of triumph, only a steady sense of alignment between truth, record, and consequence. As the hearing adjourned, executives rose slowly. Some avoided eye contact. Others looked exhausted. The authority they once carried effortlessly now felt provisional. Outside, the city continued as it always had. Evelyn stepped into the open air and paused on the courthouse steps. The noise of traffic returned. Voices overlapped. Life resumed. But something fundamental had shifted. The quiet had been heard, not because it demanded attention, but because it had been preserved, documented and presented without distortion. That was the climax. Not a shout, a record. The consequences of the hearing didn't unfold overnight, but they were unmistakable. Redwood and Blythe entered a period of enforced transformation. External monitors took residence inside the firm, reviewing procedures that had once been treated as formalities. Leadership structures were revised. Reporting lines changed. Decisions slowed under scrutiny that could no longer be bypassed. The firm survived, but it was no longer the same. Richard Harlow formally resigned 3 months after the ruling. The announcement was brief, carefully worded, and devoid of acknowledgement. He disappeared from the industry quietly, without public disgrace, but without the authority he once wielded. His legacy remained not in achievements, but in transcripts. Karen Lewis did not return to corporate HR. She accepted a compliance advisory role in a smaller organization, one far removed from power centers. Whether it was penance or recalibration, no one could say. For Evelyn, the resolution was quieter and deeper. She continued her hybrid work, dividing her time between consulting and independent oversight. Her expertise was sought not because of notoriety, but because of credibility. Organizations that contacted her did so with clear intent, to understand risk before it became exposure. She no longer chased alignment with environments that misunderstood her. Instead, she set conditions. The settlement funds faded into the background of her life, relevant only in the freedom they afforded. What mattered more was autonomy, the ability to walk away when values diverged, to speak when structure failed, and to remain silent when observation was required. The broader impact of the case extended beyond Redwood and Blythe. Regulatory briefings referenced it as precedent. Training programs adjusted language around cultural fit. Quiet employees were no longer automatically framed as disengaged. Attention began to be recognized as a form of participation. Change didn't arrive everywhere, but it arrived somewhere. Evelyn noticed it in small ways. Emails that thanked her for clarity, not charisma. Meetings that paused long enough for consideration. Organizations that asked questions instead of deflecting them. The story closed without fanfare. No final confrontation, no public vindication, no dramatic speech. Just alignment. The system had been forced to reconcile its assumptions with evidence. The quiet had proven its weight, and Evelyn, once dismissed as too little, had left an imprint that would outlast any single voice raised against her. 2 years later, Evelyn stood at the back of a small conference room, listening as a junior analyst presented a compliance concern with quiet confidence. No one interrupted. No one dismissed the question as inconvenient. Evelyn didn't speak. She didn't need to. The room paused, considered, and adjusted. As the meeting moved forward, she allowed herself a brief smile, not of satisfaction, but of recognition. Systems didn't change because of noise. They changed because someone paid attention long enough to leave a record. Somewhere along the way, being quiet had stopped being a liability. It had become a language the system finally understood. This story isn't about being quiet. It's about being observant in a world that rewards noise over truth. If what you heard felt familiar, that's not coincidence. Workplaces everywhere still confuse silence with weakness and confidence with competence. They still ignore the people who notice what others miss. Pay attention to the quiet ones. Sometimes they're the only ones actually listening. If this story made you reflect, share it. Not to be loud, but to make sure it reaches the people who need to hear it. Because systems don't change when no one notices. They change when someone does, and keeps a record.